This is Left Voices for Thursday, February 13th, 2014. I'm Andrea Sears. Tonight,
I think it's going to have a significant inhibiting factor. Unless they have a case that clearly would qualify under any circumstances as terrorism, I don't think they're going to take that step again.
Illinois' first prosecutions under a state terrorism law have failed. On February 7th, 3 protesters arrested just before the opening of the 2012 NATO meeting in Chicago were found not guilty of state terrorism charges. Brian Church, Brent Betterly, and Jared Chase had been charged under Illinois state law with material support for terrorism, conspiracy to commit terrorism, and possession and manufacturing of an incendiary device with the intent to commit terrorism. But they were found guilty of arson charges that could get them 30 years in prison and other lesser charges. Their arrest was the crowning achievement of an intense police intelligence operation that infiltrated and spied on protest organizing meetings, and undercover officers were key players in the planning and preparation for the alleged terrorist activities that never actually took place. Michael Deutsch is an attorney with the People's Law Office in Chicago, which is representing the NATO 3. He calls the verdicts on these terrorism charges a great victory.
The state had trumpeted those charges. This is the first time they had prosecuted anyone under a 2001 state terrorism law. They had asked for a $5 million bail. They had put out all these sensational charges, and our clients had been locked up for almost 20 months, and the jury pretty much rejected all the terrorism charges from the beginning. Later we were told that within the first 2 hours they had rejected each one of the 4 terrorism counts that the state had brought. So in that regard, it was a great victory because it was kind of this trivialization of terrorism, to use terrorism against protesters who were not in any way terrorists, was something that really was an expansion of the use of terrorism against political people, and the rejection by the jury was a victory in our view.
They were convicted, however, of possessing an incendiary device to commit arson and of possessing an incendiary device with the knowledge that it would be used to commit arson, as well as some lesser mob action charges. What's the distinction between being convicted of possession with intent to commit arson and of the terrorism charges?
First of all, the potential penalties for the terrorism charges were greater than the ones for arson, intent to commit arson. The other difference is it's a charge which we dispute. Basically, in our view, the intent was applied by the undercover police, who were the ones that were promoting this and were involved in pretty much directing the making of these Molotov cocktails. In addition, we don't believe there was any intent manifested by the defendants to use them in any way. It was the police, again, undercover police, talking about what they wanted to do with them. And in fact, nothing was ever done with them. And once these Molotov cocktails were made, they were immediately taken control by the undercover police, and then the place was raided. But it is a serious conviction, and it's unfortunate, and it's a situation where the jury, because of all this hoopla and because of the terrorism, I believe the jury felt like they had to find some convictions, and these were, to their view, much less serious than the terrorism ones, although it's potentially they could get a substantial prison sentence for these. We're hopeful that after the judge considers all the evidence, particularly the role of the undercovers, and particularly since nothing really happened, and particularly because a lot of the talk was more talk than action, and because they've already spent 20 months in the Cook County Jail, that he will fashion an appropriate sentence which would shortly end their incarceration.
My impression from what I've read is that these three defendants were much more Beavis and Butthead than Che Guevara. Were they convenient targets for a police entrapment scheme?
Very much so. First of all, for the several months prior to the time that these undercovers targeted these young men, the undercover agents were part of a secret intelligence unit of the Chicago Police Department. And these unit members were going around the city undercover, going to coffee houses and punk rock concerts, looking for what they considered violent anarchists. And they were trying to overhear conversations in these places and to find someone that would fit the bill of their search. And for 2 months and 30, 40 different operations, they never found anyone. So when they came across these three, particularly two of them, at a May 1st demonstration, and they were part of this Black Bloc group in this May 1st demonstration, they immediately targeted them, seeing them as potential people who they could use to create this idea that these people were dangerous. And because they were spending all this money and resources on security, they needed to justify this by making some arrests. And of course, after 2 weeks of following these guys and meeting with them and talking with them, they hadn't done anything other than a lot of talk. So like 2 days before the massive demonstration of protesting NATO, they arrested them with this Molotov cocktail evidence and then created this huge terrorism occasion in the court. And this was a way not only to justify all the money they spent on security, but also to create this fear and intimidate people from going to this demonstration, thinking, oh, wow, they're terrorists there. They're going to be people causing violence, so I'm not going to go to the demonstration. So it was kind of a twofold strategy on the part of the city, the mayor, the police chief, and the state's attorney to create this aura of fear prior to the demonstration.
What is the impact of bringing terrorism charges against a defendant rather than simple criminal charges?
Well, it affects them in many ways. First of all, it affects their bond. Their bond is much higher. It affects their incarceration. If they can't make bond, they're in the jail. If they're charged as being terrorists, they're going to be isolated. Our clients were in what they call protective custody. They had no contact with other prisoners. It creates a whole different situation in the courtroom. You're going to have more security in the courtroom. It creates a whole aura of people who come to court. They have to go through heightened security. In our case, people had to give their ID 24 hours before so they could do a check on them. And there was all these metal detectors and searches that go on. So it creates this whole idea of fear and heightened security in the courtroom. Whereas if they had been just charged with even possession of an incendiary device with intent to commit arson, it would have been entirely different. Their bail wouldn't have been such as it was. They wouldn't have been isolated in the jail, and the security in the courtroom would have been much different. To say nothing of the fear it creates in the minds of a juror. Oh, I'm sitting in a terrorism case. The state has said that these people are terrorists, and I should be supporting the state in fighting terrorists. I mean, the natural inclination of any citizen who's on the jury would be wanting to convict someone who's accused of being a terrorist. So you're dealing with all kinds of potential prejudice in all various aspects of the prosecution.
I saw a reference somewhere to a consent decree that would have prohibited the Chicago police from the kind of infiltration and intelligence gathering that was behind this case. We have something in New York, the Handshoe consent decree,
right,
that's been vastly watered down since 9/11,
right,
but is supposed to serve the same purpose. Are there restrictions on intelligence gathering by the police, especially infiltration of First Amendment protected activities?
We did have a consent decree that was in effect for many years, and then within the last 3 or 4 years, the Corporation Council of the city went to court and said, well, there's no more need for it, and they got the court to vacate it. So there was no restrictions from a court order on them from going around undercover, going to public meetings, going to demonstrations, going to coffee houses and punk rock concerts. And not only did they go, but they admitted they heard no criminal activity, yet they wrote reports and also put people's names in these reports and also checked everybody's license plate and ran checks on the license plates and put those in reports. All those things, in my view, are a violation of the First Amendment, and people are considering litigation or trying to get some kind of consent decree reinstated. But because that consent decree had been vacated, they felt they were free to do this type of undercover work. And they have a whole squad, what originally was called a counterterrorism squad, and later on changed to intelligence squad, that goes around and spies upon, infiltrates First Amendment activity. They went to all the meetings of Occupy Chicago. They wrote reports about it. And I think it's an outrageous expansion of spying that the Chicago police are notorious for and had to stop after the 60s, but now they're back.
The prosecutor in the case has said that she would bring the same terrorism charges against these defendants again tomorrow if she were able to. What impact do you think this verdict is going to have on the state's willingness or desire to bring terrorism charges under state terrorism law?
Well, of course, this is the first prosecution under that law which was passed after 9/11. So there's not a lot of occasions where they would decide that they're going to bring a terrorist prosecution. But I think it's going to have a significant inhibiting factor. Unless they have a case that clearly would qualify under any circumstances as terrorism, I don't think they're going to take that step again.
Michael Deutsch is an attorney with the People's Law Project in Chicago. This has been Left Voices for Thursday, February 13th, 2014. Join us again tomorrow for more news and information from a progressive perspective. I'm Andrea Sears for leftvoices.net.